Good morning, members of the jury. I will now begin to give you the jury instructions. If at any point you feel a need to take a recess, please just so indicate. It is very important that you are able to pay full attention to these instructions. Now that you have heard all of the evidence presented by the parties and all of the arguments of counsel, it is the court's job to give you the final instructions as to the law that will be applicable to you in your deliberations. All of the instructions of law given to you by the court, namely those instructions given to you at the beginning of the trial, those given during the course of the trial, and now in these final instructions, must guide your verdict. Counsel have quite properly referred to some of the applicable rules of law in their arguments to you. If, however, any difference appears to you in the law, as objections and statements of counsel are not evidence in the case. However, in this case, you will not be limited to the exact statements of the parties or the exact language in the exhibits. In other words, you are allowed to draw from the testimony and exhibits which are, in this case, such reasonable inferences as you may find in light of your own judgment and common sense. Members of the jury, you must recall that you are the sole judges of the witnesses called in this case. Only you can determine the weight that that testimony gets. When looking at credibility of a witness, you may wish to believe all of what that person said, only a portion of it, or none of it at all. In looking at it, you should carefully weigh all the testimony you heard and all of the circumstances under which every witness has testified. You need to consider every matter which tends to show company was negligent in one or both of these respects, and also has the burden of proving to you that it is more likely than not that this negligence was the proximate cause of the injuries the plaintiff sustained. If you determine that the plaintiff met the burden of proof on these two issues, then it will be your duty to decide what damages are appropriate. One of the things we should discuss is what does negligence mean in this context. First of all, negligence means the failure to use ordinary care. Then you must define what that means. Ordinary care is defined as the care a reasonable person, or in this case a reasonable company, would have used under the facts of this case. Now, a maker of goods can be held liable for negligence if it failed to warn a person of a known danger with the product, but the plaintiff has the injuries which were caused by the product in question. She must prove that by a preponderance of the evidence. I am going to take a moment to instruct you on the area of damages. The fact that that court is going to instruct you on damages or on the proper measure of damages should not be considered by you as in any way suggesting any view that the court has as to whether or not the plaintiff should or should not recover in this case. These instructions are presented to you solely to assist you in the event that you should find in favor of the plaintiff in this matter. If you should decide that the plaintiff has proved by a preponderance of the evidence that the defendant was negligent in one of two specific ways that she alleges and that this negligence was the cause of her injuries, then she may recover damages. It will be your duty as jurors to consult with each other with a view towards reaching an agreement in the... Good morning, ladies and gentlemen. We've now arrived at the final stage of the trial prior to the commencement of your deliberation that is devoted to the charge on the law, the instruction at length concerning the legal principles applicable to the evidence that has been received. I've already mentioned some of those principles. I'll now review and supplement those instructions in that regard. The first, and in many respects the most important, is that both sides are entitled to a fair, honest, impartial verdict at your hands, no more and no less. You were chosen to serve on this jury because you promised under oath to render a verdict. As you're aware, it's been my function to preside during the course of this trial, and further, my obligation to do so fairly and impartially. The court determines all questions of law. and it is your sworn duty to accept and apply